I made a similar argument in another case recently with less results, where there were several members of the jury that were moved to that point, but there was another cadre that wasn't, and got a little backlash probably. It wasn't an angry argument, but it was more of an empathetic argument for my clients who very seriously hurt. This guy was very seriously hurt in a motorcycle wreck. And I made this argument to the jury and got almost a little teary, where I almost lost my composure, but didn't. That's the last thing you want to do, is lose your composure. And there were certain members of the jury that were really moved by it, and there were other members that had a little bit of a backlash because my client hadn't really totally sold himself and his situation to the entire jury. And so it didn't go as well. But the point is still the same, and that is just how important it is to attune emotionally to a jury. And the way law students are taught today, they've got to recover the ability to do that after they get out, because it gets squelched right out of them when they're in law school. It's really a shame, a tragedy, not just for their life in trial, but for their personal lives. I can't tell you how many students have said, boy, after taking your course, my girlfriend or my boyfriend or my significant other is, really liking who I've become. They like me a lot better. I've really learned how to deal with some issues that have come up. And I'm sure that'll transfer over into how they deal with other lawyers, and how even my undergraduates, who a lot of them are lawyer wannabes, how they deal with their fellow law students and the legal profession after they get out. Sometimes there are cases, in fact, there are a large number of cases, and in my experience that's pretty much what I handle, where there are power imbalances between the parties, where one party's done something to another that they have absolutely refused to take any responsibility for. And unfortunately, our legal system encourages them not to take responsibility for it. It encourages them to dig in, to defend, to not give anything away, to not give the other side any slack, any compensation, or any opening. And so that's what one side does. And the other side, who is generally on the downside of that power imbalance, because the party that was the perpetrator, and it's not always that clear who the perpetrator and who the victim is, but often there is a party who's been a perpetrator, and the person on the other side is on the downside of the power imbalance. They don't have what the big power corporation or insurance company or whoever it might be has. And the only way sometimes to get those parties on the high side of the power imbalance to do the right thing is to litigate with them, because they won't do it voluntarily. And at the same time, I've always believed that you really do your best to make it easy for them to do the right thing. You try to keep it from being, you try to keep the litigation from getting polarized. Now, there are lots of lawyers who say polarize the case. Polarize the case, because if they've done wrong, you want them to be as defensive as possible, because that'll really piss the jury off. Of course, if you're on the defense side, in that situation, the smartest thing you can do is take responsibility where responsibility is clear. And where it's not clear, then you work it through. You try to work it out. And if you can't work it out, then you're in a position to defend yourself if it's not so clear. And on the plaintiff side, which is generally where I am, my experience is that the defendants who are most self-righteous fall the hardest. The best results I've ever gotten are where defendants make the zero offer, or the amount of money that might as well be zero, because they're so self-righteous about their positions. That's where the biggest results come in. It's the folks who are much more even-handed about taking responsibility where it's harder to prevail as a plaintiff, because they're trying to be at least reasonable about what they're offering. So my suggestion really to everybody is if we're all a little bit more reasonable, then we get these things dealt with in a more productive manner. The sad thing for me, though, is even when both sides are reasonable, you still hear mediators saying, well, good settlement is when both sides are unhappy, because both sides are giving more than they thought they would when the day began. Both sides' expectations are being disappointed. That's really a sad state of affairs to me. It's really a shame that that's the mindset we're in. But unfortunately, it's been very difficult in our culture to shift the dynamics and to get people to agree to resolve disputes based on an objective analysis or a third-party point of view analysis on what's happened, rather than rather than both parties defending their points of view. It's really a challenge to get folks to do that. When that happens, it's magical and it's very peaceful, and people actually get along better when it's over with. I mean, one of the things that I've really hoped to see happen is that when we resolve litigation, I always at least hope that parties can feel closer to one another than they did when all the strife started. It doesn't happen very often, particularly dealing with institutions, because there are institutional rules that keep that from happening. That's not an objective of it at all. And it's sad that it's not an objective. If we all dedicated ourselves to resolving whatever dispute came up in a way that caused people to be actually emotionally closer to each other, I think people ultimately would save a lot of money. I can't prove that because nobody's really tried it, honestly. But I think that would be true. Be a whole lot less money spent on all this. You know, actually there was a book by a conservative named Francis Fukuyama several years ago called Trust. And his thesis was that in societies where there's high trust, the transaction costs in about everything are lower. You know, if you can walk into a grocery store and the grocers don't have to worry about you stealing things, they don't have to keep things behind the shelves and have, you know, an individual hand you the stuff and collect for it like they did in the old country stores here in this country. You know, people walk and stick things in shopping carts and pay for them, and with the expectation that people actually will pay for what they put in their shopping carts, and they won't try to stuff them in their sweaters and overcoats and hide it and steal it like that. And you take that principle and you apply it to legal dealings, lawsuits. And if you could really trust people to really be honest with one another and be objective about the litigation or about the matter under litigation, and that level of trust would dramatically reduce the transaction costs. I mean, it really makes a lot of sense. It's a question of getting people to try to do that. I've actually written a couple of pieces about how to do that, but it really takes a new language for lawyers. They need to start thinking about relationship agreements. Like collaborative law. Collaborative law is sort of an institutionalized relationship agreement. The agreement there is, you know, we're going to make full disclosure, we're going to hire mutually acceptable experts, go make decisions based on essentially objective standards. You know, if lawyers could sort of voluntarily do that, even without the structure of the collaborative law movement itself, then that would be a productive thing.